Hello everyone and welcome to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. Today I'm joined by Kelly Dickson, partner from the Australian law firm Macpherson Kelley, and we are going to discuss about the recent news of a big data breach incident in Australia. So first of all, Kelly, thank you very much for being with us today. And secondly, let's go through this relevant topic. So what happened? Can you tell us a bit more about this data breach?
Absolutely. And thank you for having me today, Alessandro. It is the case that I think around the world, people have been starting to hear about the Optus data breach case that has recently occurred in Australia. So it just happened at the end of September, and it was one of the biggest, maybe if not the biggest, data breach incident that has occurred in Australia. So the incident happened to Optus, which is owned by Singtel Optus, but it's one of our telecommunications providers here in Australia. And they have had almost 10 million customers' information compromised. So that was for current customers, but also for a lot of former customers as well. So nearly 10 million customers, that's about 40% of the Australian population. So it's quite a big data breach here. There were about 2.8, nearly 3 million customers who have had quite sensitive information compromised. So that is their driver's licenses or their passports. So that puts them at greater risk of identity theft and fraud and those sorts of things. And there were also about 37,000 Medicare cards as well that were compromised. So some people say that it was a cyber attack. Some people say that there were some perhaps lax security procedures. And so Optus is also now, aside from regulatory interest, is also looking at some class actions here as well.
I can imagine, and the numbers are huge and impressive. So thanks a lot for giving us some more information. And I think a lot is yet to come to better understand, what happened and which are the reasons behind. But I think that there is something that, under the legal perspective, that for you as a legal expert and a privacy expert, we can learn. And in general, which are what can businesses learn from a situation like this or an experience like this one?
Yeah, I think that really for businesses, there are three very key learnings. And the first one is that privacy compliance is a thing. Businesses need to do it. So I think this is a really good reminder for businesses. You've got to deal with privacy compliance. But I think also for businesses about data security and making sure that there are proper practices in place for that, particularly for data minimization. Only collecting and storing what businesses actually need, I think, is a really important thing. Think about things like, can some of the information that you need in your business just be cited instead of actually recorded? Because you can't lose or compromise what you don't have in the first place. Also, data retention has become really important. Have a policy, use it, follow it. And for things like expired information, make sure that you're deleting that, destroying it, de-identifying it when it is no longer needed and when it is out of date as well. And particularly for data breach reporting, have that procedure in place as well and use it. But I think what the Optus case has also demonstrated in Australia is that because there are so many Australians who have been affected, for some of them, it's the first time this has happened for them. And I think that there can be enormous reputational damage. There's a lot of discussion in Australia at the moment about, is Optus a victim or a villain in this as well? So I think that businesses need to be very aware about the content and tone of their communications and making sure that they're complying with these things and being ready if there is an incident like this that occurs.
Yes, thanks a lot, Kelly, for answering to this question. And I agree with you. There are, many reasons why privacy and data protection can be key in a situation like this for businesses. As an European, under GDPR, we have the concept of so-called risk minimization that would have helped probably in a situation like the one we are talking about, because of course, less data you have, the better in a situation like this. The other point, as you said, one of the main risks for companies exactly a damage of the image of the company itself. And this is something that we as Privacy Rules are working a lot with, and that's why we cooperate not just with legal and cybersecurity experts, but also with communication experts that can support us rebuilding the image of the company, or at least minimizing the damages that the companies can have, because sometimes the way in which you communicate with the authorities, or the way in which you communicate about certain cases or certain information with your clients or your followers makes a big difference in which is going to be the damage of the company reputation. So thanks a lot for touching on these points. I have just one last question for you, and is related to the laws and regulation in Australia. Given what happened and how much regulation in this regard could have helped, and knowing that Australia seems to be a bit behind on this, do you think that this is going to make, to push for any change in Australia under the regulatory standpoint?
Yeah, I do. And I think that the Optus incident has really brought into focus that Australia's privacy laws are quite a fair way behind, particularly GDPR and other parts of the world as well. So I think that there's perhaps a little bit of embarrassment for Australia that this could happen, and particularly in relation to fines here. In other countries, if this had happened, Optus would be facing fines likely in the hundreds of millions of dollars. In Australia, our maximum fine is about $2 million. So I think we will see our fines increasing here in Australia. But Australia has also had some proposed legislation to make our privacy laws stronger. And that's been around for a while. But I think that this case will really accelerate the introduction of those laws. And I think that we will see privacy changes happening a lot more quickly in Australia. So I do think that we will see some new guidance about data minimisation, as you were saying, and also about data retention, and having some principles built into our privacy laws for that, as well as what was already being thought about in Australia, which was increases to penalties, a direct right of action for individuals to be able to sue, and some strengthened technical requirements and those sorts of things. So I think also we will see those come through a lot more quickly than if they were just progressing through legislation normally.
Absolutely, absolutely. Cases like these always push countries, governments, and organizations to move forward. I think it was a perfect occasion to let people, companies, and authorities understand the need to regulate and to proceed as soon as possible in protecting data and such kind of information, in particular when they are very sensitive. So Kelly, thanks a lot. We running out of our time, but thanks a lot for this brief intro on the Optus case. It was extremely interesting, and I think a very good case to study and to learn from for next steps, not just for Australia, but all over the world. And it will be interesting to see what's going to happen in the future there. So let's stay in touch. And thanks a lot for being with us for this Privacy Espresso.
Exactly right. Thank you for that.